Last week, we had a seller's son show up to closing completely confident he could sign the paperwork for his mother. He walked in, sat down, and said, "Don't worry, I have a power of attorney." Sounds simple enough, right? Well, unfortunately, no one had let the title company know that the seller wasn't actually showing up and that the son would be signing for his mother. So the entire closing came to a screeching halt. Not only were all the closing documents now wrong, but the title company also asked one very important question. Do you have the original power of attorney document with you? And there was silence. And unfortunately, that was just the beginning of the problem. Hi, I'm Caitlin with Legacy Title Agency. And after handling thousands of real estate closings, I can tell you that selling property with a power of attorney can either be incredibly smooth or an absolute disaster. And usually the difference comes down to preparation. A power of attorney, often called a POA, is a legal document where one person gives another person authority to act on their behalf. The person giving the authority is called the principal. Usually this is our seller. The person receiving the authority is called the attorney in fact or agent. This is usually the person showing up to our closing. And no, that does not mean they're automatically an attorney. It simply means they've been authorized to act for someone else. Now, in real estate, powers of attorney can be common when someone is elderly, sick, traveling, hospitalized, overseas, or they're just physically unable to attend closing. And when done properly, they can make selling a home much easier. But this is where people start getting into trouble. Before we can even use a power of attorney, we usually need to make some contact with the principal to confirm they really are trying to sell their home, and we'll want to verify the sale is actually legitimate. And this is the part most people don't realize. In Michigan, for a power of attorney to be valid, the principal, the person giving the authority, generally needs to sign the document, understand what they're signing, and be of sound mind at the time that they're signing it. And the document itself needs to be properly notarized as well so that we can use it for our real estate closing. This is incredibly important because families sometimes wait until someone is already experiencing serious cognitive decline or medical issues, and then they try to quickly create a power of attorney at the last minute. And if the person no longer understands what they're signing, that can create major legal problems. A lot of people think, well, once I have a power of attorney, I can act forever. And that is absolutely not true. No power of attorney survives death. The moment the principal passes away, the POA is over. And this can create some enormous confusion in real estate transactions. Families will say, well, I handled everything for mom before she passed, so I can still sign. But legally, that authority may have ended the moment she passed away. And now the property may require probate, a personal representative, or this is one of the biggest reasons closings get delayed unexpectedly. Now, let's talk about the issues that cause absolute panic at closing tables. The original document. Because title companies will typically need the original signed power of attorney so it can be recorded along with the deed. And this can catch some people off guard. And suddenly they realize nobody knows where the original document actually is. Now everyone's searching through filing cabinets, calling attorneys, digging through safes, overnighting documents across the country, all while the buyer and lender are waiting to close. This is why we always recommend providing the power of attorney to the title company as early as possible. And hey, if you use legacy title, we will remind you of this a few times, including the day before closing, just to be safe. Now, here's another major surprise for many families. Even though the attorney, in fact, is signing the documents, the sale proceeds still belong to the principal, the actual seller, meaning the money is still supposed to go into the principal's account, not the attorney, in fact's personal account. So it's incredibly important to make sure the proper bank account is ready, wire instructions are verified, and everybody understands where the funds are legally supposed to go. Now, here's another thing people underestimate. The attorney, in fact, often needs to know quite a bit of information about the transaction, because during the closing, they may need to help provide the principal's social security number. They may need to provide contact information or forwarding addresses for the principal. And trust me, discovering missing information while everyone is sitting at the closing table is very stressful. Now, thankfully, most power of attorney closings actually go very smoothly if everybody prepares early. That's really the recurring theme here. Preparation prevents panic. Because when you send that POA to Legacy early, we can review it early and coordinate everything early for you. So these transactions become incredibly simple for our clients. It's the last-minute surprises that create chaos. So let's simplify this. Here's what we need to remember when selling property with a power of attorney. The principal must properly sign the POA while of sound mind. The document needs to be notarized, and no POA survives death. Title companies typically need the original document for recording, and the attorney, in fact, needs to be prepared with important transaction and identity information. Handle those things early, and the transaction will go smoothly. And remember, if you're buying, selling, or investing in real estate anywhere in Michigan and want to avoid costly closing mistakes, make sure to choose Legacy Title and subscribe to Legacy Closing's YouTube channel. And we'll see you in the next video.